Today we're going to talk about the difference between a power of attorney and a personal representative with a probate. Full disclosure, I am not a licensed real estate attorney or estate planning attorney, so if you have any questions about this, reach out to me. I can refer you to one or reach out to somebody in your local market to get the best advice possible. This video is purely educational and based around making sound real estate decisions as somebody who is working with multiple sales every couple months that are power of attorneys or probate sales. So let's dig right into it, guys. Let's talk about power of attorney. This is going to be set up for somebody who is actually still alive, right? This could be your brother, sister, aunt, uncle, mom, and dad, somebody who needs help with management of their finances, moving on to the next stage of life, liquidation of their real estate holdings, managing bank accounts, opening, closing, and making decisions for somebody who is not there, right? And when I say not there, I mean presently they need help, right? And so things like a durable power of attorney remains in effect if the principal becomes ill or disabled, versus a regular power of attorney, which is a document that can be drafted by an attorney and notarized, but is not court appointed. And we'll get into that in a second. So the power of attorney is essentially going to give the attorney in fact, the person in charge now, the ability to make decisions on the other person's behalf without having the person there, right? If they need to pull out money or pay bills or get a listing agreement signed with a real estate agent, that power of attorney is going to be key in getting that process started for somebody who's still living. You're going to see a lot of this as people age and they're around to downsize and move into senior living facilities. You're also going to see this when people are going to move in with a family member like their son or daughter that essentially need to sell their house and make that transition with living closer to family. Now, what I want to tell everybody about power of attorneys is that document, that original document that's notarized, is extremely important, and not only to sign a listing agreement with a real estate agent, but also to close the property and have the title company verify its legitimacy. I just had a sale that was going on that we only had the copy of the power of attorney, which was just caused absolute chaos about 5 days before closing. And then we finally did locate it. But what I want to tell you is lock these documents in a secure location. Make sure that you have copies of that document, and make sure, this is one of the biggest things, that the power of attorney specifically has language that allows you to deal with real estate holdings. Some power of attorneys do not mention real estate or liquidation or selling properties or any real property type of decision. And you got to make sure that it specifies that, because some title companies will not allow the sale to close because the power of attorney does not give them the overbearing authority to make that happen. And that has also happened to me. Next, what I also want you to know about power of attorneys is making sure that you have that document available when you meet with a listing agent in order to sell the home. They're going to need that to provide that to their brokerage that gives you the authority to sign on their behalf. Making sure you know how to sign those documents is going to be key. And I have an example of that I can share with anybody on how to specifically put your name and their name and attorney of fact so that all those documents are signed correctly. And lastly, making sure that the person that you have a power of attorney over is aware that you're selling the piece of real estate. And I want to be very keen here and getting that through everyone's head. Make sure the person is aware that they are selling the real estate. The title company typically is 4 to 5 days before closing is going to make a verification call. That verification call is essentially going to be a phone call where somebody reaches out and says, "Hey, Tim, Mary, are you aware that your daughter, Steve, is selling your piece of real estate and is going to close in 5 days?" And I've actually been in the title company the day of closing when they've done that. I've actually seen it happen 4 or 5 days before closing where they couldn't get a hold of the person, and then it's turned to friction and having to be reactive in the situation instead of proactive. So really defining that with your attorney and the competent legal counsel of, does this power of attorney A cover real estate liquidation, but also what is the mental capacity of the person I do have a power of attorney for, and is it durable, or does this need to move to a court appointment, which we'll talk about. Now, that's power of attorney. It's going to be a document that you share with your listing agent. It's the document that the title company is going to need, and make sure it is the original and make sure it's been drafted and notarized, and all of that, those questions and concerns are dealt with through an attorney. Now, moving on. A court appointment, which is going to be a probate sale, is going to elect somebody, either the administrator, the executor, or personal representative, using the letters of testamentary, the letters of administration, which are going to be the certified letters that you get from the county that give you the permission to sell the real estate, just like a power of attorney, but on the probate side. And typically what you're going to have to understand is it dependent administration versus independent administration, which means, is it going to be court supervised versus do you have the full authority to make all the decisions and then get all the way to final distribution, and that will be solved. But one person is in charge versus the court basically supervising everything about the process. Seek legal counsel to understand that in that process. I know about it. I'm certified in talking about it when it's relating to real estate, but that's a question you're going to need to figure out. That document, those letters of testamentary, is going to elect you the personal representative. And now this is a recorded document with the county. That is essentially going to be the document, just like the power of attorney, that you give to the listing agent who hopefully understands probate and has done probate before, that it gives you the authority to sign the listing agreement that does not match the title report and who the legal owners of that property are. So that's what you really guys have to understand. You're signing listing agreements to sell somebody's property, but that does not match the title report or the legal names on the deed. So as a personal representative, you need to understand valuation of that property. You need to understand that you should probably interview a few agents, especially ones that are certified in probate or have experience in probate. And also that you're making a good decision in terms of why and how you're selling that. Are you selling it off market to an investor? Are you going to put money into that property and put it on the market, right? All of those different options. Is it as is, go to the market? All of those decisions are going to be based upon your authority as the personal representative and having the certified letter that elects you the personal representative. And this is going to deal with somebody who has deceased, where a power of attorney is with somebody that is still living. And so I say all of this because there's issues that can come up, right? If you have issues with not communicating with the other heirs about you listing the property, right? And in California, the notice of proposed action, your NOPA, is going to essentially allow everyone to know that is involved with the estate that the personal representative is going to sell the property. And I want to make sure that you're getting good legal advice from an attorney who can walk you through each state. But in the state of Oregon or California, those laws are going to change. So make sure, as the personal representative, the family is on board, everyone is comfortable with what you're doing, and the notice of proposed actions, or whatever your state is going to essentially define that as, is that you're making good real estate decisions in the best interest in the fiduciary responsibility of the estate, right? Just like you are the power of attorney, making the best decisions for the person you are attorney in fact for, making sure that you are making the best decisions for the estate, right? It's not about just having an investor call you tomorrow and saying, hey, I can buy the property all cash as is, and then you sell it for $200,000 less than what it's worth. As a real estate agent that works in probate, my job is to evaluate all options and help you make the best decision so you can maximize the return to the estate. And so that is really the difference between the both. Now, there is a middle lane here in terms of conservatorships, guardianships, and all of the other different types of court appointment. And we'll discuss that in the seller property disclosure video that I'm going to do here in the next couple weeks. But I wanted to really explain what's the difference between a power of attorney and what's really the difference of letters of testamentary and being the personal representative of the estate, and how to operate those two in terms of where you are in the process, deceased or still living, and how to sell the property and avoid some of these roadblocks that come up. You can go to www.oregonprobateagent.com. There is a Calendly there where you can push and schedule a call directly with me. If I can't answer your questions, I can refer you to a licensed attorney who can. If you're pre-probate, meaning that you haven't filed your affidavit, I would love to talk to you about how to prep that property for listing. I also can give you resources in terms of junk haulers, estate sale companies, landscapers, handymen, any and everything that was related to getting that property ready to be marketed. I'm here to help throughout that entire process. If you've already filed the affidavit of court, you have your letters of testamentary or administration, and you're moving forward, I just want to give you some quick advice here. Don't just use the real estate agent that your attorney refers you to. I always try to tell everybody, get 3 opinions, not only on value, but experience and also their marketing ability, right? I'm gonna stop this video for a second and talk about their experience, their pricing valuation, and their marketing ability. Somebody may have great probate experience, but they suck at marketing, horrible photos, right? Their ability to generate tons of showings, tons of saves, exposure, shares, showings, offers, equals more money. And you're, as a fiduciary of the estate, your best interest is to get the maximum amount of money. So if you just go with the real estate agent that your attorney says, hey, use this person, I've used them for a bunch of deals, doesn't always mean you're getting the best person for the situation. And so that is going to be one of the commonalities of objections that I get when I'm calling probate leads that have already filed with the city or the county. Oh, I have an attorney, they're handling everything. No, you don't. Your attorney does not have a license to sell real estate. Your attorney needs to be able to provide you references or referrals to people, but you should be getting second, third opinion by somebody who is outside of this little ecosystem of their referral network. I'm just gonna be honest, guys. I've had attorneys that are horrible do deals with me, who have blundered at the day of closing, have delayed transactions, and at the end of the day, they referred somebody else, right? So every attorney is going to be different. We have a vast network of people who can help you in that process. So go to www.oregonprobateagent.com, click the calendar link, find a time that works for you, invite the family members and heirs that are going to be involved in that decision, get everybody on the call, and let's talk about where you are in the process. Let's also talk about who we may need in order to assist this. But ultimately, my job at doing this and making good decisions is based upon my own family's experience and all the headaches that can come up. So I appreciate you being on this video. If you have any questions, you can visit us at www.oregonprobateagent.com. You can reach me at 458-209-0163. Call, text. Thanks again, and I'll see you on the next one.